Hey guys, David Tarras, head of the Federal Criminal Defense Practice at the Rosson Law Firm. What we're going to talk about today is one of the primary ways that we get great results for our clients when they have either pled guilty or been convicted of a conspiracy-related offense. Now, obviously, in any case, we're going to overturn every stone, look for any potential motions that can substantially reduce your criminal exposure, potentially and certainly explore the possibility of a jury trial and be prepared to do so we don't miss anything. But a lot of cases in the federal criminal justice system do result in pleas, and we have to consider that and the best ways to get a favorable outcome for our client. A lot of different charges that we face often involved co-defendants or at least co-conspirators involving a conspiracy, a federal conspiracy. Okay, and when you're involved or alleged or charged to have been involved in a conspiracy, a few unique things come into play as it relates to the federal criminal justice system, the process, as well as the sentencing of an individual who is charged as a member of a conspiracy. And what we're going to focus on today is role adjustments under the federal sentencing guidelines when someone is involved with other participants in criminal conduct, and specifically mitigating role adjustments. So the guidelines, when we talk about mitigating role adjustments, we're talking about successfully arguing for our specific client based on their role that the judge is reviewing when fashioning a sentence for our client, and we're arguing for at sentencing, their role, our client's role in the overall conspiracy, and certainly as it relates, and most importantly, as it relates to the other participants or their co-conspirators or co-defendants in an attempt to have our client get a reduced sentence if we are successful in arguing that our client was less culpable than the other individuals involved in the conspiracy. Conspiracy cases can be extremely overwhelming. They can be hard to defend. You do need an expert criminal defense attorney like the federal criminal defense attorneys at the Rosson Law Firm to defend them. Because what's so difficult about them is no matter what your role was in the conspiracy, even if you were a very, very minor participant, even if you didn't know the overall plan, if you didn't take any action towards completing the conspiracy, there are a lot of ways the federal government can still prosecute you as a conspirator. If you are a voluntary and knowing participant in criminal activity with other people, and at least one person took some action towards achieving the goal of the conspiracy, even if it wasn't you, even if it wasn't our client, and regardless of whether or not the conspiracy is even completed. So if we do end up in a situation with a conspiracy case where our client has entered a plea with our advice or has been convicted after a trial, we definitely always want to argue for our client to get a reduction under the sentencing guidelines based on their role as it relates to the other participants in the conspiracy. And there are a few ways to do that. The United States sentencing guidelines allow for three different levels, three different types of reduction for having a what we call mitigating role or a mitigating role adjustment for our client in a conspiracy. You can either get 2, 3, or 4 points off if your attorney successfully argues for you. Now, if you get 2 levels reduced, if we're arguing for you to have a 2-level reduction in your guidelines based on your participation or lack thereof relative to your co-conspirators at sentencing, in your case, that means that we are arguing that you were a minor participant in the conspiracy. To get 4 points off, the defense, and for any mitigating adjustment, whether it's 2, 3, or 4, the defense has a burden by a preponderance of the evidence for 4 points to prove that you were a minimal participant in the conspiracy. If it is unclear, or if the court ultimately finds that you might have less of a role or might have been less of a participant than minor, but not qualifying for minimal, then that's where that 3-point in between the 2 and the 4-point level reductions comes into play, if you're somewhere in between minor and minimal. Now, having a minor role is described as being less culpable than the other participants in the alleged criminal offense conduct, but not to the point where your role could be deemed to be minimal, which would result in a 4-point reduction. Minimal is under the relevant law, and each district has different law as it defines minimal and as it interprets whether or not someone is eligible for a mitigating role adjustment in the first place, and whether or not it should be minor, 2-point off, minimal, 4-point off, or somewhere in between 3. Minimal is most commonly defined as someone who is far and away least culpable individual in a group of people who were charged together or co-conspirators and participating in your relevant offense conduct. And usually, as a lot of courts will define, the court's going to have to see that your role in the conspiracy was either inconsequential or somewhat peripheral. Different courts define it different ways, but there are a set of standards for the court to consider when deciding whether or not you should be eligible for a 2, 3, or 4-point level reduction if they do find that you are, first, less culpable and worthy of a reduction, a mitigating role adjustment at all. What they'll look for is your knowledge, and what your defense attorney will have to argue is a lack of knowledge of the overall scope of the conspiracy, decision-making authority, or discretion regarding the planning and operation of the activities that made up a conspiracy or the criminal conduct, personal involvement, personal participation, and the acts that our client actually took in furtherance of the conspiracy as it relates to the acts that another co-conspirator or other co-defendant might have taken, as well as the proprietary interest or what our client stood to benefit, whether it be financially or property-wise or otherwise, from the criminal conduct itself as it relates to the other charged individuals, the other co-conspirators, the other participants in the case. It's very important to consider that what the law says is when arguing for a mitigating role adjustment for points off as a minor participant, 2 points, minimal 4 points, or somewhere in between, your conduct, and what we have to argue as the federal defense attorney, is that your conduct is compared to the other participants in your specific case, in your specific conspiracy or criminal activity or organization, not generally speaking what your conduct was in relation to what generally speaking in a, let's say, drug trafficking organization or drug trafficking conspiracy, what the average participant in that looks like. It is specifically on the facts of your case, and it's very, very nuanced. So if you are facing a situation, or if we together as a team have gotten to a point in your case where we are deciding to enter a plea to a charge that involves co-defendants or co-conspirators, or you have been convicted after trial, we do absolutely want to be prepared. You want to have the best federal criminal defense attorney to put you in the best position to get points off of your guidelines, levels down by arguing that you had a lesser role in the conspiracy. We're experts in doing so at the Rosson Law Firm, so please do not hesitate to contact us.